My name's Stephen Woodhouse. I'm a solicitor here at Stephenson's, and my job is to advise employers and employees in relation to a wide range of employment law matters such as unfair dismissal, redundancy, discrimination, unpaid wages and pregnancy and maternity. I think one of the best things about employment law is that it's fast-paced and constantly evolving. So in recent times we've had issues around furlough, coronavirus, new health and safety regulations, and also issues around vaccinations and jabs. So it's a constantly evolving area of law and something which you've got to keep on top of and constantly think on your feet. Well, a redundancy will typically arise in a number of situations. The first and perhaps most common one is where there is a reduction in the need to do work of a particular kind. Alternatively, you might have a situation where you have the same amount of work to be done, but that work can be reorganised amongst staff, so you need fewer employees to undertake the same level of work. The second most common issue which arises in redundancy relates to consultation. Where you have a larger scale redundancy, for example more than 20 employees, then there are minimum periods of consultation which are required. However, even where the minimum periods of consultation are not required, such as redundancies with less than 20 people, there is still an obligation on businesses to undertake a fair and meaningful consultation process. And again, a failure to do so could result in a finding of unfair dismissal. And a third example is where a business is closing down a site or closing down altogether. In those situations, redundancies will be necessary. Similarly, in situations where an employee is on maternity leave, they have extra protection from redundancy. If in a redundancy situation a suitable vacancy arises, then it must be offered to the person on maternity leave at the behest of other employees who are not on such leave, without the need to go through a competitive interview process. And a failure to correctly pool staff can taint the rest of the redundancy process and is likely to lead to a finding of unfair dismissal. It's important that when you're applying the selection criteria you use objective factors rather than personal opinion, which may cloud your judgment and render the process unfair. I think for an employee it's important that they make the most of the redundancy consultation process. Generally speaking, it's the employer that leads redundancy processes as a whole, but the consultation process is an opportunity for the employee to gather as much information as they can and ask questions on things that they disagree on. It's also important that they challenge the pool for selection during the consultation process if they're not happy with it, challenge any scores that they've been given, and also push for alternative positions which may be available within the company to avoid redundancy. A key message that I give to both employers and employees is to get advice from an early stage from Stephenson's. I've been involved in many cases in the past where businesses have approached me halfway through a redundancy process, and we've had to unpick a lot of the mistakes which have been made and sometimes start again. So it's important that you do take that advice from an early stage. It's not fatal if you take advice halfway through, but if you do take advice earlier on in the process, it will save you time and money in the long run. Here at Stephenson's, we're on hand to provide personal, professional and cost-effective advice for you during what can be a difficult and complex situation. We offer a no-obligation consultation to assess the circumstances of your case and determine the best route forward for you.